Hi, hello, welcome to the Pushpaganga YouTube channel. So in the last class, we had started with the polity questions that were appeared in the UPSC examinations, Prelims 2021. So now in this in this section, we are just continuing with this. So now in the last class, we had completed around 10 questions. So now we'll be continuing from the 11th question. So now here it is. So with the reference to the Indian judiciary, consider the following. So consider the following statements. Okay, he has given two statements and he has given options for that. So now, which is this statement? The first statement says that any retired judge of the Supreme Court of India. He's speaking about the retired judge, not the current sitting judge. Any retired judge of the Supreme Court of India can be called back, can be called back to sit and act as Supreme Court judge, to sit and act as Supreme Court judge by the Chief Justice of India with the prior permission of the President of India. So next point, a High Court in India has the power to review its own judgment as the Supreme Court does. So now here the key important words that we need to consider is the Supreme Court, retired judge of the Supreme Court, Chief Justice of India, and can sit and act as the Supreme Court judge and the President of India. So here he has given few options. So the statements given above which are correct. So now the most important thing that we need to note is whether it is not correct or correct. Here it's correct. So now A 1 only, B 2 only, C both 1 and 2, D neither 1 and 2. So now here any retired judge of the Supreme Court of India can be called back to sit and act as the Supreme Court judge. Yes, it is possible if the Chief Justice of India, due to the heavy work pressure, they are called as an ad hoc judge. So now accordingly this answer will be right, and a High Court in India has the power to review its own judgment as the Supreme Court does. Yes, this is also possible. So the answer for this is C, both 1 and 2. So now let's see for this how the explanation, again detailed explanation of this is. So now under 128 article of the Constitution, the Chief Justice of India may at any time, so as I said earlier, due to the heavy workload or heavy work pressure, at any time with the previous consent of the President, he has to take the permission of the President. So now President requests any person who has held the office of Judge of the Supreme Court. So the most important thing that we need to note is he has to call only the person who has acted as the Judge of the Supreme Court earlier. So now not as a Judge of an High Court. So now to sit and act as a Judge of the Supreme Court. So they are called as ad hoc judges, at the time. So now the second statement, High Court can review its own own judgments under Article 226 of the Constitution. So now according to this, both the answers are right. So now we are going with both the options. So for this question, answer C is right. We'll go with the next question, the 12th question. This is related to the citizenship chapter with reference to the above statements. Which are consider the following statements. What is that? So he says that the first statement, there is only one citizenship and one domicile. A citizen by birth can become the head of the state. A foreigner once granted the citizenship cannot be deprived of it under any circumstances. So now answer for this. So now here it says that there is only one citizenship and one domicile. So now definitely India has adopted the single citizenship, and this single citizenship has been borrowed from Britain Constitution, that is UK Constitution, and one domicile. What do you mean by domicile? Domicile is a region where our citizen is permanently wants to reside or temporarily. He is residing in that particular place, that is called as a domicile. Yes, there is only one citizenship and one domicile, and this is true. So now if we go with the other options, so this will be wrong and this will be wrong, and we have left with 3. So no need to think about this, because obviously this will be wrong. So he says that a citizen by birth only can become the head of the state. So this is not right according to the Indian Constitution. Only in America the citizen by birth can become the head of the state, but in India citizen either through birth, descent, naturalization, or registration, or the process, or if he becomes a citizen of India through acquisition of a territory, can also become the President of India. There is nothing but the head of the state. So now this is So this will be wrong. So second also will be wrong. So it is already deleted. So by the elimination process, only 3, you need to jump with the 3. A foreigner once granted the citizenship cannot be deprived of it under any circumstances. So a person, a foreigner, if he becomes a citizenship, if he gets citizenship through a process of naturalization, so definitely he can be removed. He can be removed under certain conditions. So which are the conditions? So which are the conditions? These conditions will be like, so if for example, if he has if the registration or the certificate of naturalization is obtained through fraud, if he is given a fraud documents or if he has given a malrepresentation, in that case he can be that citizenship can be deleted. So according to section 10 of the Indian Citizenship Act. Okay, so now citizen has during any war in which India may be engaged. Okay, so now he has unlawfully traded or communicated with an enemy, he has supported the enemy, so now not supporting India on against India, then in that situation the citizenship can be deprived. So now the citizen has been orderly resident out of India for a continuous period of 7 years. Okay, he has been orderly resident of India, out of India. Once he gets the citizenship of India, he's been out of India for continuously 7 years, then his citizenship will be cancelled. Okay, so now the answer for this question is there is only one citizenship, so we go with option A, only one. So this is wrong and this is wrong. Okay, so now the reason is India has only one citizenship, as we explained earlier, and one domicile. A person not born in India but having acquired citizenship by registration or by naturalization can become the head of the state. Okay, so that is nothing but the President of India. So this one we explained about the section 10 of the Citizenship Act, where a person can be deprived by his or his citizenship. So now the answer for this, the 12th question is A1 only. Now let's move to the next question. So so which one of the following factors constitutes the best safeguard of liberty in a liberal democracy? Okay, so now here, what do you mean by liberty? So following factors constitutes the best safeguard, okay, best safeguards of liberty, so in a liberal democracy. What do you mean by liberal democracy? Here it says like this: liberal democracy is nothing but liberal, like it's free, there is no bound, there is no conditions restricted like that. It says that liberal democracy emphasizes, okay, liberal democracy emphasizes the separation of powers. Okay, we have a separation of powers. We have executive has its own power, legislature has got its own power, judiciary has got its own power, then an independent judiciary and a system of checks and balance between the branches of the government. So it's like no one has an arbitrary power, something like that, and everything will be under the control. So this is called as liberal democracy. Okay, so now each and everyone has his own responsibilities, has his own independence. So now the answer for this is D. There is nothing but separation of powers. Here the separation of powers, as I said, the component or the objectives of liberal democracy is nothing but the separation of powers or independent judiciary. Goes with like this. So now the answer for this 13th question is D, separation of powers. Okay, we go with the next question. We adopted parliamentary democracy based on British model. We adopted parliamentary democracy British model, but how does our model differ from that model? Okay, so now we have got with that because we know that, right, the concept that is borrowed from British Constitution. Mainly the main concept that is borrowed from British Constitution is between the parliament system, the parliamentary privileges, the legislative procedures and prerogative writs, single citizenship, and the cabinet system, rule of law. All these factors we borrow from the British Constitution. So main thing is the British Parliament is a supreme or sovereign. So it says that according to the British parliamentary democracy, as regards in the legislation, the British Parliament is supreme or sovereign, but in India the power of Parliament to legislate is limited. So now how does it explains? Okay, we'll finish off with this. In India, matters related to constitutionality of an act. Okay, so matters relating to the constitutionality of an act. so of the parliament are referred to the constitution bench by the Supreme Court. Okay, anything, yes, anything, any matters. We'll go with the second one, second option is quite easy task. So if you go with this, in India, matters related to the constitutionality of an act, for example, anything that has been dealing with the constitutionality of an act, so Supreme Court can interfere from that. Supreme Court have an upper hand over it, so it can take it by a review of an act are referred to the constitution bench by the Supreme Court. Okay, so for example, any cases relating to coming down with the Supreme Court, for example, if Parliament passes an act relating to abolition of the privacy, right to privacy, or fundamental rights, anything curtailing over that, anything that coming under the constitutional one, so Supreme Court will refer it to the constitutional bench. The constitutional bench either starts from 5 bench, 9, 11, 7, it depends upon the seriousity of the cases. Okay, so anything that will be referred to the constitutional bench of the Supreme Court. Okay, so now here, as regards to the legislation, we'll go with as regards to the legislation, the British Parliament is supreme or sovereign, but in India, the power of Parliament to legislate is limited. As it is like, for example, so like whatever the legislation made by, for example, if anything, the Parliament passes any law, it is not ultimate. So, for example, Supreme Court come and say regarding to the land reforms, it might be or 38th Amendment, again 39th Amendment. Now, Supreme Court says that, so it is being bounded because it is under the Constitution. Now, in India, the Constitution is supreme. The Parliament cannot breach the Constitution. So, as we saw in the previous questions, everything will come under the Constitution authority. Okay, the rules and regulations, everything will be framed under that. So, whereas in British Parliament, legislation might be supreme. In most of the cases, 90%. So it might be the British legislation is supreme or sovereign. But in most of the, in 10%, it might be either on the case. So based on this will be like 90% right. So this is 100% right. So definitely this cannot be the answer, and this cannot be the answer either. According to us, the answer will be C, both 1 and 2. So probably UPSC might go with B also. So either in these two, the answers can go with that. Okay, so we'll go with both 1 and 2. So 2 can also be right answer, because if they take, because we go with referendum, Scotland referendum and all. So in the Brexit cases, many of them deferred leaving the European Union. So in that perspective, 2 can also be the answer. 1 can be wrong. So anyway, majority, if you go with that, C can be the right answer. So now, anyway, we spoke about that. Again, I'll explain about this parliamentary sovereignty. Parliamentary sovereignty means the parliament is superior to the executive and judicial branches of the government. Is superior to the executive and judicial branches of the government. But in India, it is not superior. Each and, as we said, separation of powers, each and everyone has equal powers. So now, and can thereafter enact and repeal any law it chooses. So in theory, as I said, UK Parliament could enact legislation which oppresses 90%, 95% of the population if it chose to do so. However, the political consequences of such a measure mean that in practice, this is very unlikely to happen. Okay, but in theory, it is there. In practically speaking, it's very much difficult to happen. Okay, so the Constitutional Court is the highest court in the country when it comes to the interpretation, protection and enforcement of the Constitution. Here, we are dealing with the second statement. Okay, so now it deals exclusively with constitutional matters, those cases that raise questions about application or interpretation of the Constitution. So like, for example, we have seen a number of cases, like it might be Golaknath case, it might be right to privacy case on the Bharati, so Putswamy case. So anything that related to constitution matter, it has to be transferred to the constitutional bench of the Supreme Court. Okay. So the answer will be either, according to us, it will be C, or UPSC might go with either B or C. Okay. So now here we go with the next question. With the reference to the union government, consider the following statements. Okay, with the reference to union government, consider the following statements. So now it says like this. Okay, N. Gopalswamy Iyengar committee suggested that a minister and a secretary can be designated solely for pursuing the subject of administrative reform and promoting it. Okay, In 1970, the Department of Personnel was constituted on the recommendation of Administrative Reforms Commission 1966, and this was placed under Prime Minister's charge. Okay, so now this was not placed under the Prime Minister's charge. Again, we'll go with this explanations given under here. So now in 1970, on the basis of recommendations of Administrative Reforms Commission. Okay, so in 1970, on the recommendations of ARC, so ARC Commission led by Morarji Desai, the Department of Personnel was set up in the Cabinet Secretariat. Okay, it was the Department of Personnel, DPAR, what we call exactly, but now the DPR is under the in charge of the Prime Minister. The Prime Minister holds the same portfolio. So the DPAR was under the in charge of Cabinet Secretariat when it was formed. In 1973, the two departments were merged to form the Department of Personnel and Administrative Reforms, today what we call as DPAR. Okay, so today's DPAR in the Cabinet Secretariat. In 1977, the DPAR reforms was transferred to the Ministry of Home Affairs. Okay, so in 1977, this was transferred. The Ministry of Home DPR was transferred to the Ministry of Home Affairs. So this portfolio was placed under Shri Ram Nivas Mirdha when it was brought into picture. When it was in 1970, this portfolio was placed under Shri Ram Nivas Mirdha. So based on this, this option is 100% right, 100% wrong. And N. Gopal Somenga suggested that a minister and a secretary be designated solely for pursuing the subject of administrative reform and promoting it. So on the rough scale, this also is wrong. So the answer is D, neither 1 and 2. Okay. So now, right to privacy. So now we are coming under the last three questions of this chapter. So now here he speaks about right to privacy. So now, what is right to privacy? Right to privacy, this is the direct question, no explanation is required for this, is protected under which article of the Constitution? So now Article 15, no, this speaks about discrimination, about prohibition of discrimination based on caste, religion, sex, this speaks about that. So this is wrong. And Article 19 speaks about 6 freedoms. So freedom of association, profession, speech, expression, those kind of things, he speaks about that. So this cannot be the right answer. And Article 29 speaks about cultural and educational rights. It speaks about that. So this cannot be the right answer. So the right answer will be Article 21. Okay. So now let's move to the next question. So answer C, it's a self-explanatory. So now we are going with the next question. So 17th one. Consider the following statements. In India, there is no law restricting the candidates from contesting in one Lok Sabha election from 3 constituencies. Next, in 1991 Lok Sabha election, Shri Devilal contested from 3 Lok Sabha constituencies. Then, as per the existing rules, if a candidate contests in one Lok Sabha election from many constituencies, his or her party should bear the cost of by-elections to the constituencies vacated by him or her in the event of her winning in all the elections. So this is a straightforward question. So we all know that. So this was, yes, this was there is no law right now. After 1977, few changes was made. It was only like Atal Bihari Vajpayee. As per the records we got, it was the first where Atal Bihari Vajpayee had contested in 3 constituencies. So now at currently, so 3 constituencies is not permitted. 3 Lok Sabha elections is not permitted for a candidate to contest in the elections. So this is wrong. Going with this, one only, that will be wrong, and this also will be wrong. So let's check with 2 and 3. So now, as per the existing rules, if a candidate contests in one Lok Sabha, so the cost of by-election to the constituencies is vacated by him or on the event winning in all the constituencies. So it is not borne by the party or the candidate. For any by-elections, if a candidate contests in one Lok Sabha, one assembly, and if he resigns, so candidate can contest in 2 Lok Sabha. Like for example, so Rahul Gandhi had contested, we contested in Amethi and as well as in the south, in Kerala, one of the constituencies in Kerala. So I just name is just coming, I forgot about it. So here it starts with Yeah. So if if Rahul Gandhi had won in both the constituencies, if Rahul Gandhi had both in both the constituencies, then he need to had resigned in one constituency. So then the by-election for that constituencies will be borne by the government, not by the candidate or by the political party, not the Congress. So this is wrong. So by elimination process, even though we know whether this is right or not, so this will be the right answer if you go through the elimination process. So now in Lok Sabha, Sri Devilal contested from 3 Lok Sabha constituencies. Okay. So now answer for this is B. Okay. Now a candidate can contest from 2 constituencies maximum in Lok Sabha elections, which is right now the rule over that. Before 1996, sorry, I was wrong. Before 1996, there was no restrictions, and after the amendment made, so earlier I said 1977, it's 1996. So after the amendment made to section 33 clause 7 of the Representation of People Act 1951, the limit is fixed at 2. Earlier there was no restrictions. It was like three constituencies. The earlier restriction was 3, but after 1996 there was some amendments made, and it was limited. Restrictions was fixed to 2 itself. In 1957, Vajpayee had contested in 3 Lok Sabha constituencies. It is Lucknow, Balrampur, and Mathura. Okay. The government based the cost of re-elections that takes place in the constituencies. It's not the political party, neither candidate. Okay. So now answer will be B. Okay. So now going with the last question. So here it's consider the following statements. It's a question based on the government reforms. Okay, historical background of India. So the Montague-Chelmsford reforms of 1919. So the name of this Montague-Chelmsford reforms is the Government of India Act 1919. Recommended the granting voting rights to all the women above age of 21. So the Government of India Act 1935 gave women reserved seats in the legislature. So now by giving with a healthy guess, going with the first statement, so now granting voting rights to the women above age of 21, it's quite a complication. Okay, we can't, it's not like it's very difficult to say whether they have given the voting rights or not. So statement 1 is wrong, as it did not recommend the granting voting rights to all the women above the age of 21. So based on this, so we know that, so this was not the right answer. So it didn't give the voting rights for anything. So now based on this, 1 is wrong. So we'll go with not both, and 1 is wrong. So now either we have an option with B, 2 and D. Okay, so now the Government of India Act gave women reserved seats in the legislature. Okay, sorry, gave reserved seats in the legislature. So now this is quite a competitive one. In many of the books we can see it's for different sections of the people. The Government of India Act 1935 gave women seats for the legislature, and in many books says that again D, neither it didn't give. So again we go with the answer either B and D, but we choose it was the reserved seats for the legislature was given. So my answer will be B, or in UPSC we can go with either B or D. Okay, both the answers we can just expect over that. Okay, so now, this is about answer. This is about 18 questions that we solved or came across the UPSC, UPSC preliminary examinations. So these were the polity section. Today I have just covered about the polity sections which we had discussed in the last session, and as well as with these sessions. So I hope you enjoy this session, and any doubts or any queries you can just ping us and with the mobile number given below. And this book for simplified quantitative aptitude is one of the books that has come out from our publications, and this is a book which is useful for all examinations, even for UPSC examinations, IAS, IPS and CDS examinations, for all management examinations, SSC examination, banking examinations, and it is available on in Amazon, Flipkart and other stores also in our nearby areas. So any doubts related to the polity section, you can just write down in the comment box, and anything else. So I hope you enjoy this session. Thank you for listening to us. Have a nice time.